Hi, we're back again. So, third-party placement and contractors. This session obviously may not impact everyone, but I would say one of the biggest changes in the H-1B program in terms of policy memos, how USCIS are adjudicating H-1B petitions, involves companies that do any type of third-party placement of their H-1B workers. In our opinion, at least in my opinion, this is one of the top agenda items of the current administration in attacking the H-1B program. They feel that it is less it's easier to convince the population that the program's being abused by looking at the H-1B third-party placement. There were a lot of challenges by computer technologists in the Disney case we heard about, where people were saying, we're hiring our replacement who are foreigners coming in. And so there was a big backlash, and they kind of put all their heads together and said, yeah, we want to go after these contractors, ignoring an entire industry that has been built up because of the demand and the need for top talent and IT technology workers. But how the current administration looks at this is how can we can't change the law because Congress is not very active, so how can we, through policy, try to make this a very difficult visa to get? And so we're here to talk about what changes we have seen come out and how we need to respond back in order to keep these important workers in our economy and at businesses. So one of the first cases that came out was a few years ago called Matter of Simeio. Potato. Don't work there, don't know how to say it. But this was a big case that kind of took everyone by surprise. The Administrative Appeals Office came out with this case and made it a precedent decision, which is very rare. What this means is they've made a binding on the agency, and now everyone has to follow this. And what it did is it discussed what is considered a material change to an H-1B petition that you file. Essentially, the case said, if your worker changes from full-time to part-time, that's a material change, and you need to file an amended petition. If your employee changes worksite location, so if they're working on a project in Minnesota and you need to place them in Iowa, that's a material change. You need to file an amended petition. Previous to this decision, an employer was only obligated to file a new labor condition application for that location, post it prior to the employee starting work there, and document it in their public access file. This is no longer acceptable unless the employee is only moving within the same metropolitan statistical area, meaning the same coverage base of your LCA, then that old policy still applies. So Matter of Simeio has opened up a few things. First, when you file an amended petition, as Laura mentioned at the beginning of the talk, they've rescinded their memo that used to say if we previously approved your application, we should probably approve it again. That's gone. So every new filing you make, every amended petition, you may have had working brand new scrutiny. So the employee you may have had working for you for years who just changed worksite locations, you now have to prove the petition up from the very beginning, including such things as right to control your employee. You have to prove that is still a specialty occupation. You have to reprove everything you've already included in your first petition, running the risk that they could deny your case. So one of the things you look at is when you don't have to, when it's not a material change, when you can move your employee and it doesn't require an amended filing. Lon, you want to talk a little bit about the short-term placement rule?
As Deborah, good afternoon, everyone. Since this is my first time to present here today with you. Deborah mentioned about the focus on third-party placement, and it's really serious, and we'll talk a little bit about that also during the enforcement section of the presentation. But what employers really need to remember is that there are exceptions to when an individual changes work site. When an employee changes work sites, you don't always have to file a new LCA or an amended petition. There are two exceptions. One is when it's a short-term placement. The Wage and Hour Division has issued a memo stating that in a situation where an individual is placed for a short-term period, that means specifically 30 days at a certain site or less, 30 days or less at a certain site within a year, there needs to be the site that you're placing the individual cannot have a labor condition application filed by that employer. You have to be responsible for the travel to that work site, provide lodging costs, meals. If it fits under that definition where the individual is at that work site for less than 30 days a year, you do not have to file a new H-1B petition. Now, that can also be 60 days in a one-year period at one work site if it meets off the criteria I listed, as long as that individual has a permanent work site or desk at your headquarters or at a main office. That short-term placement definition could apply even if that individual may be placed at one work site in a year for 60 days or less. So that's really important to remember. I know that prior to matter of Simeio, we often relied on this provision in order to give us time to prepare new petitions when the individual may be moving permanently to a new position, where we had that 30-day period that we could rely on. Another exception to the material change requirement is for roving employees. And what that means is if they are in a position that is innately, that requires travel, peripatetic employee where they have to, sales representatives, they have to travel place to place, that does not require new petitions to be filed in the situation where you may have a sales engineer, for example, which would meet the H-1B definition. Also, the time at a work site cannot be more than, I shouldn't use work site, the place at the location cannot be more than 5 days at a time also to meet that definition of roving employees. You can also have casual short-term basis, which means that they may travel to certain locations, and that can be for no more than 10 days at a certain location. So make sure you consult with counsel in terms of to determine whether you need to file a new petition or not, because we often forget about these exceptions when we're talking about material change and when we hear new work site because of this definition. You want to be in compliance because of the increased focus on enforcement, but there can be exceptions to certain situations.
One other factor, thank you, Lon, it is a good reminder, myself as well, is to think about material change is also looking at the job the individual's doing. So in a 3-year period of time, many of your employees, if they're good, are going to get promoted, right? They're going to advance, and you want to encourage, obviously, advancement and placement. And so what we also get is, can I accept this new position? And so we strongly urge to have us review it. There are times where it's very similar duties. Maybe they have a little more independence, or they're getting a small bonus or raise, and we would say, no, it's a natural progression within their position. You're fine. They can continue on. But sometimes maybe they've moved up from being a role to a manager. Now they have direct reports. Now they've had, you look at the duties, and there is a significant change where you would actually change their occupational classification. It may require an amended filing. So those are other factors that you may need to revisit when you first filed the H-1B to bring HR in again to take a look at that. That may result in a new amended filing as well.
So do you want to talk now about the next attack on third-party placement, which was the February 2018 USCIS Memo?
Can't forget, right after Valentine's Day, this company's on third-party placement. I represent quite a few consulting companies. And so when this memo came out, it caused, a bit of consternation and determining how are we going to address this going forward, because this is a true attack, I think, on the IT consulting industry. And one of they did in this new memo is reiterate the Buy America, Hire America, basically as a message to say this is the mantra that we're going to look at your petitions, right? So they're looking at it to say, is this at all harmful to U.S. workers? Well, there's always a question. Any type of contractor is there, are they not filling a job that maybe would be hired by a U.S. worker? I think that's really beyond the purview of immigration, and it's not in the regulations for H-1B. But what this new memo comes down to is really outlining essentially they want to see all your contracts. So if you are contracting, you have a vendor, for example, for a a systems analyst and they're placed at a third party, they want to see every layer within that chain. So if you are, say, a mid-tier consultant or you're the end client, you're going to need to acknowledge that you have an H-1B worker at your work site. You're going to maybe want to provide an end client letter confirming the duties and the role that they're performing. Then your vendor is going to be disclosing its contract with you. It's going to be disclosing its contract with its subcontractor. Hopefully not like 4 or 5 layers, but that can happen, I think, and that's what they're getting to. Part of this stems from what they consider a few things. What is the right to control? They are really looking at what is an employer-employee relationship. If you are a contracting company, how do you prove that you really know what your employee is doing every day if you're not there, right? If they're in Texas and you're here in Minnesota and they're working on a second vendor's contract, they want to know, how do we know they're really doing this specialty occupation work? You gave us a job description, but you're not there. Prove to us that you are still their employer. So for example, you may need to provide payroll records, what benefits are being employed. You may need to provide performance reviews to show proof that you are reviewing them. How often you do weekly check-ins, call-in logs. Some people have site, they send supervisors there monthly to check on their workers if they have a large staff. All of that is to your benefit to prove you have this employer-employee relationship. And one of the things I say, if we're not the employer, who else is? But this then triggers other areas of employment law, right? Is it eroding the independent contractor relationship? Is it trying to find joint employer rights? And so I think it's very important at the outset, any type of consulting or third-party placement, to make sure you may need to put clauses in your agreements that we're going to disclose your contracts to the government, because that's something coming out. Also with the type of specialty occupation. The job you've described them doing in your H-1B petition needs to match the job they're actually doing at the end client, which if they have multiple work sites or multiple different vendors within that 3-year period of time, it could change. The other category they're looking at is an itinerary, which is nearly impossible to predict where someone will be 3 years from now if you're in this type of position. And so what we're seeing is a few things of limiting H-1Bs to the duration of the contract. I think that's something we have to be prepared for. But if you're going to be filing an amended petition anyway, it's not the end of the world. It just kind of triggers your timing. But I think you're not going to have as much wiggle room. It's going to be much more harder to say, oh, it's a never-ending contract that'll go for 3 years if you don't have proof of that. So be diligent and cognizant of your documentation, because this will tie into what Lon's speaking about, site visits.
Yeah, and just to add, I think what we have to remember is at the beginning of every case where you do have an individual who's going to be working at a third-party work site is to really strategize. You know, what do we see here in terms of this person's employment in the next year or next 3 years, and what's the best strategy to put this petition together? I was presenting on another panel, and it was very interesting because in terms of the request for the end user letter clients, the whole point of third-party placement is that you have to show that you, the sponsor, the employer, has control over this employee, and yet they're asking for us to provide letters from end user clients to state exactly what they'll be doing and to explain how the position or the duties that they're performing is a specialty occupation too. So some of the letters can be written to say, look, they work here, we don't know everything they do, this is what we've retained their employer to provide in terms of services to us, but we're not the employer here. So that's another strategy to take. We're going to talk a little bit about FDNS site visits, which is fraud detection, national security site visits in the context of third-party placement. Around the file in 2017, as we were getting decisions from our H-1B cap cases, we heard a lot about raids against employers who were hiring subcontractors or employers who place a lot of their employees at various client sites. So there's been a lot of enforcement activities around employers who do place employees at third-party work sites, but also those those clients who use these subcontractors are also getting these visits from the FDNS regarding whether the individual is really being placed at their work site, their location. So it's really important if you're an employer who use subcontractors to be prepared for these type of work site visits. And we'll talk a little bit more about it later. But as part of the FDNS visits or worksite visits, USCIS, the investigators can go to any work sites listed on that petition. So if you have a contractor or subcontractor working at your work site, you did not file the H-1B petition, but you need to be prepared for a visit perhaps by USCIS. And that is an area that we're really looking closely at in terms of collateral consequences of these worksite enforcement activities. Is a lot of employers have subcontractors working for them, and you shouldn't have to know what's going on, because that's the whole point of having those contractors. But we are seeing USCIS increase its visits to these third-party work sites and asking questions. We're seeing it also in communication from the Department of State also. So I think it's really important for you to be prepared for it. For those who have H-1B employees, make sure that your employee are aware of these worksite visits. They can interview not only the HR contact who may be at your worksite, but also the employee, the foreign national employee. They should be prepared for it. Your labor condition application public access folder that we often provide to our clients. If you work with attorneys and you file H-1B petitions, you need to make sure your public access folders are in order because these investigators can request it. Anyone from the public can come in and request for inspections of these public access work folders, and just really be prepared. Have one person who is responsible to respond to these type of worksite visits. And we'll talk a little bit more about that too in terms of preparing for it. Deborah, you want to talk about Department of State and CBP?
Sure. So in line of what other agencies are kind of harping home on these poor third-party placement workers is Department of State and Customs and Border Protection. We'll discuss later increased vetting, but part of this vetting process happens when your employees are applying for their H-1B visas. How many of you had employees undergo administrative processing when applying for a visa? Anyone?
Wow.
Seriously, you guys are awesome. I want you all as my clients. So administrative processing happens when individuals apply for visas and the consulate is not yet ready to issue their visa. It could be a variety of reasons. They could be conducting background checks, name checks, security checks, but we're also seeing a greater review of the H-1B petition, and they're following up with what's been filed. So that includes, we've seen the consulate send emails to the end client to say, did this person in fact work for you and are they still placed there? If that employee has already left, and the end client said, yes, absolutely, they were here till April, and now they're no longer placed with us, that person's not getting a visa. We have seen CBP, they now have greater access to phone records. A case was just emailed to me I haven't read yet, which can't be good when it's sent from the criminal law group. Basically providing access to review people's phone records and their computers when they travel. I've consulted on a case where someone reviewed their email records that they were sending out to try and find party location and said, this is a different resume than what was included in your H-1B. Are you being truthful? And so this is the type of scrutiny that employees are getting. So in a great world, they would never leave. They wouldn't travel till we got everybody green cards. But when they do, they're opening themselves up to investigation. So when you do travel, be sure you know where your employees are going. You know that they have their proper documents, that they know who's their contact at the company to call to verify their information, and make sure nothing's changed, that they're disclosing to you exactly everybody is on the same page of where their work site is.
So we already talked a little bit about subcontractors at worksite, but I just want to end with a reminder that when you write a letter to be submitted to the Immigration Service, if it's your H-1B petition or someone else's H-1B petition, you need to make sure that the information in that letter is accurate and you have confirmed exactly what has been stated. What happens is that employers who are asked to provide end-user client letters sometimes may not know exactly what their employees are doing or what that individual may be doing. And if you're making a statement that you're having an employee perform certain activities, you need to confirm that information. We have seen the Department of State issue emails to individuals who write end-user letter clients to confirm, who are these individuals? Do you know what they're doing at your work site? Who wrote this letter? How many workers do you have who is a subcontractor and who has the right of control over them? So we're just seeing an increase in scrutiny with third-party placement, and it's in line with Buy America, Hire America.